Hi, Segura.
Hi, everyone. Pretty much everyone knows me. I've been doing criminal law and family law for about over 20 years now. When Mark asked me to do this and asked me to talk about the interplay of family law and criminal law, the first thing that came to my mind was domestic violence. Because if we think about what affects most of us in family court, it is domestic violence. And it mostly affects custody cases. And how it does it in a legal way. When you're going through a divorce or you have a parentage action, or what we call SAPSers, suit affecting a parent-child relationship, the people or the parents are called conservators. And the presumption is that parents are to be named joint managing conservators of their children. And the conservatorship is the relationship that a parent or a person has with that child, and that basically designates the rights and duties that that person has with their child. So the presumption now, like I said, is that the parents will be JMC. When I started practicing family law, there wasn't that presumption, and mostly the mother, or the custodial parent, was the managing conservator, and the other parent was called the possessory conservator. So now, parents are JMC. However, if there's a finding of domestic violence, then the court or the law says that that parent can't be named a JMC. So when you're dealing with an assault case, misdemeanor, you really, like in immigration, you'd really try to do everything you can, or should, if you think about it, or if you know that person has children, maybe going through a divorce or is trying to establish paternity of their child, is to make sure that there's not a finding of domestic violence. And I know that's harder to do, but if you can, take that into consideration. And sometimes prosecutors will recognize that, and if you can point out to a prosecutor that the guy may be a piece of, shit boyfriend or husband, but he's a really good dad, and point that out, and point out that that will really would adversely affect his rights going on in the future, sometimes they'll agree to do that. And that has happened to me because I knew enough to present enough information to the prosecutor to make them realize that it was a good decision in that case. So surprisingly enough, though, and I've had a case where a man, and I was the amicus, that was the attorney representing the child. The code says that if a person is a finding of domestic violence, that person cannot be named a managing conservator or joint managing conservator. However, it doesn't say that that person can't be named the sole managing conservator. And so we actually did get around that, and we actually got the dad who had a finding of domestic violence named sole managing conservator, and the worthless mother was named the possessory conservator. So that doesn't happen often, but that's something to consider for those of you, and I know there are lots of you out there that do practice family law that haven't thought about that. You can have that person be named sole managing conservator. The other place that domestic violence does come into play is spousal support. In Texas, we don't call it alimony, we call it spousal support. And to qualify for spousal support, there are 3 requisites. One of them is you have to be married 10 years or longer. You have a child that requires substantial care or personal support after the age of 18, or the spouse has been convicted of or on deferred for an offense that constitutes family violence that occurred up to 2 years of filing of that divorce petition. So you could have somebody that's only married 2 years, but if they've been convicted of family violence, the spouse, the wife probably in that case, could ask for spousal support. Now that's different from temporary spousal support, which is you ask for in any divorce petition when you file for divorce and you have parties that are separating and you have a spouse that doesn't work. That's going to be different from the spousal support. I don't know if any of you are interested in practicing family law, but spousal support is not the most common. It's not that easy to get. It's not like in other states where alimony is a given. So it's something you have to work for. Temporary spousal support, however, is different, and usually you do get in the beginning of a divorce. Okay? I don't think the injury doesn't matter. And I think it's just a factor because in determining spousal support, the courts look at all the factors. This just says that it allows you to even ask for it. So when I say you have to be married 10 years or longer, that doesn't mean you're going to get it. I mean, spousal support is never a given in any case. So it's just a factor. Okay. And I haven't had a case where I've had to plead for it or had to been able to plead for it. So it doesn't have to be.
Does a 10-year marriage requirement require that they be together for 10 years? 'Cause say they were together for 9 years and it took a year of separation and pending divorce to get the decree. Technically, they have a 10-year marriage.
Right. No, you just have to file 10 years. You just have to be married at least 10 years before you file. So yeah, sometimes people come in and we say, just wait 5 more months. Just make that marker so you can ask for it. And like I said, but it doesn't mean you're going to get it.
But what if they've been separated say, for a year because again technicalities?
Doesn't matter. You just have to have been married at least 10 years. Now, right, because again, the factors for determining who's going to receive child support, I mean, that could be a factor, but in determining spousal support, it's a matter of you take into account the division of property and the need of the spouse that's requesting it. So if you've been separated and and you're surviving on your own, chances are you might not even need it and you're not going to get it. The next thing that I thought of was protective orders, and I think maybe a lot of you have defended against protective orders. They are different than the MOEPs that we're used to over here. They're not automatic, and they don't get them just because, and they're treated like any other evidentiary hearing. They have to prove, when I say they, let me just say that most protective orders are brought by the district attorney's office, but private attorneys can also bring them. You can file your own protective order for a client. So anybody can bring a protective order. They are all now held in the 280th District Court. Judge Lynn Bradshaw Hall is the one that hears all protective orders. She was here in the civil courthouse, but now they moved her over to the juvenile courthouse. She hears all of them. And what whoever files them has to prove is that domestic violence has occurred and that it will most likely occur again. And that's what I think that we as defense lawyers can usually hang our hat on to define and fight against it, is that it will likely occur again. Because they may be able to prove that it occurred, but then they have to really prove that it's going to happen again. And that's where a lot of times we win. The other thing about protective orders, unlike MOEPs, is that they last up to 2 years. When your client is served with a protective order, you need to know that when they come to see you, you're going to have very little time to prepare for that hearing. They don't really reset protective orders over there. The only chance you get getting a reset is if your client only received notice of that hearing 48 hours from that hearing. Otherwise, you're going. But most of y'all know Beth Barron. She's the one that handles all of those over there. And I've known Beth Barron forever, and she wouldn't give me a reset for anything. So resets don't happen, right? They just don't happen. So be prepared. It's a bench trial, but take all your witnesses, take any evidence. Anything you can do. It's just like a mini trial, but you just have to do it really fast and be ready. You're going to have to weigh that the ability of your client to testify. If you've got a criminal case pending, it's probably not a good idea, because Beth has got that, it's court of record. They've got that, the court reporter there, and that's going to come over and invite you over there. So what we usually, or what I've done usually when I have a case over here, and if I can't fight it because the only witness is my client, I agree to it. If there's no chance of winning it, and you can agree to them, and you can agree to them by not admitting that family violence occurred, but just agreeing to the protective order, saying, fine, I don't care, I won't get around her, I won't come near her. And Judge Bradshaw Hall allows you to put in there that there's a finding of domestic violence only for the purposes of enforcement. And that protects you or your client, again, from the custody issue, and also protects you over in criminal court. So if you have to agree to it, do so, but make sure that that language is in there. And also, if you're going to agree to it, try to do whatever you can to make sure that the children aren't part of that protective order, because they'll go ahead and file it and include the wife and the kids or the girlfriend, anybody else, you know, that's in the family, and you don't want that. You want to limit that protective order as much as possible, because unlike those MOABs, these basically say you can't go around their home, you can't go around their school, you can't do anything, and that's certainly going to affect your custody fight. So agree to them, but do so really carefully. Judge, if you're going to do a protective order, I would recommend that you go and speak to the clerk and the coordinator of the 280th. Judge Bradshaw Hull is very particular. She has her rules. She has forms that she expects you to fill out prior to being there, and I can't emphasize the importance of going there before. To think that you can just show up, no, not in that court. They don't treat you very nicely. They expect you to know what the rules are. So I learned my lesson the first time. I will say this, that she does deny a lot. You can win protective orders. Sometimes when we read those affidavits and you're just going, oh my God, she's going to come and testify, she listens, and I found that she does deny several. So, good.
I found it's useful to walk the complaining witnesses to their story, even when you try it later on in the criminal case. It's sometimes useful to let them testify in the protective order so that they're walked into their story.
Oh, that's true. That's true. If you don't put your client on, sure, you can use it as a fact finding. Absolutely. Mm-hmm. Oh, she loves to hear herself talk. Mm-hmm. Mm-hmm. Oh, it's painful. No, I agree. Being in there is painful. And she just expects you to be there and to be ready to go when she wants you to go, and you have to stay there until she is done with you. And she talks like this, very, very slowly. So yes, very, very painful. Also, child hearsay, it is admissible in a protective order if the allegation is against the child. Something to know. I mean, I'd still object, but just to know that it is admissible under 406. That's all I have on protective orders. Kristen. The only thing I think of is because they wanted all the family courts together. That's the only, I don't know why. Yeah, yeah, yeah. Sure. You can try to go back after a year and ask her to reduce it, but I think it has to still be a year. And you can negotiate it for a year, but I don't think I've ever gotten one less than a year. Have you, Crispin? Has anybody gotten less than a year? I think a year is the minimum that you can try to get. Okay. Yes. You still have to file a motion and have a hearing. It's not going to just happen. You know, Marcus, I don't know. The ones that I've had have been a year. Do you have a question?
Actually, that was the same question.
Mm-hmm.
I know in another county, they have kind of balance on it. And even when the applicant wants to undo it, because she didn't realize when she got to the lawyer, and he agreed to all just incredible conditions that really interfered with their business operation. So, you know, I had her prepare an affidavit, this and that, and I wanted to go over and undo it. And, it was 4 or 5 months into the paperwork. Man, we can, go through that.
It's hell.
Go to hell and back.
Yeah, yeah.
Well, that's the same question of what is the difference with applicants trying to undo it?
I- I've only had two, and they were denied. So, yeah, it's not easy to undo. Mm-hmm. Yeah. Yeah. Mm-hmm. Okay. The next aspect of a family law that has some criminal nature to it are enforcements. Enforcements of child support, because people can be incarcerated for not paying child support. So, it's a case that maybe a criminal lawyer might want to take, because it's not overly family law, but know that the rules of civil procedure do apply. And I think that's one thing that anybody that wants to do family law needs to know, is the rules of civil procedure apply everywhere. If you're going to take an enforcement action on child support, to know that after filing your answer, or included in your answer, you have to allege affirmative defenses. And they're listed in the code, and I've listed them for you. Voluntary relinquishment, if the child is left with your client. If your client lacked property that could be sold, mortgaged, or otherwise pledged, or lacked ability to provide support in an amount ordered, attempted to unsuccessfully borrow money, or knew of no sources from which money could have been borrowed or legally obtained. If you don't allege those in your answer, you cannot bring them up in court, and you're just going to get thrown out. And so whatever you do, you might as well, if you're going to take on one of these cases, allege it all and just be safe, because if it's not there, you're not going to be able to bring it up in court. Yes, sir.
I noticed there's a thing I don't see in there, is for enforcement, you have to personally serve the defendant, even if there's you can't just send the paperwork to the attorney.
Absolutely not. Yeah, absolutely. If you are going to file an enforcement action, yes, the respondent has to be personally served. Yes. And the lawyer, you could ask the lawyer if they'll accept service, but most family lawyers know not to accept service on those, because you don't want to accept service on that. You want them to you don't want to facilitate an enforcement action against your client. So yes, personal service is basically a requirement. Okay.